We begin tonight with breaking news from the courtroom. A judge has uncovered inconsistencies. The court issued a decisive sentence, 20 years. Now we take a closer look at how this case developed. Tori, the investigation, court proceedings, and key moments that led to today's verdict.
This is one of those cases that stays with you. A 13-month-old baby girl named Olivia, a daycare worker named Sarah Fuson, and a video that changed everything. Sarah was convicted of aggravated child abuse after surveillance footage showed her forcefully slamming Olivia down 8 times during nap time. The final blow left the baby motionless for 35 minutes. Today we're in the sentencing hearing, and what you're about to hear is going to break your heart in more ways than one.
Your Honor, my name is Macy Hyde, and I am the mother of Olivia, the child who has been deeply harmed in this case. There are no words to describe what it feels like to realize your baby has been harmed by the very person you trusted to care for her. When I first saw the bruises on Olivia's little arms, I felt a mix of confusion, fear, and indescribable pain. I had trusted Sarah with the most precious thing in my life, my daughter, and that trust was shattered. I am here today to share the profound and lasting impact the defendant's actions have had on my daughter, on our family, and on me as her mother. Since the abuse, our lives have been consumed by emotional turmoil, fear, and uncertainty. Olivia, though too young to fully understand what has happened, continues to suffer the effects. For months after the incident, she woke up screaming in the night. She had panic attacks and was showing an overwhelming fear of sleep. Putting her down at naps and bedtime became an emotionally charged ordeal. Even a year after the abuse, she still exhibited signs of trauma. We had to seek play therapy because she refused to let us touch the backs of her arms. And she displayed concerning behaviors during play, acting out as a student or a teacher, which hinted at her distress. A simple touch in the wrong place could trigger a meltdown, with Olivia begging us not to touch her that way, as if she was reliving the horrors. As a mother, the emotional turmoil has been unbearable. Every day, I live with the constant anxiety that my children may be hurt again, fear that grips me every time I drop them off at school or leave them with anybody other than myself. Things that once felt routine, like school drop-offs, babysitters, and play dates, are now moments of intense dread and second guessing. I regret deeply that I took Olivia back to Sarah the day after the abuse. The guilt that haunts me for that decision weighs heavily on my heart, and I still to this day struggle to forgive myself. After watching the trial videos, my husband and I experienced nightmares, uncontrollable tears, and unable to shake the images from our minds. We both sought therapy to cope with the trauma, including EMDR, to help erase the haunting memories. Rewatching the footage in October just reopened old wounds, bringing back intense pain in the memories of that time. Our daily life has been irrevocably changed. My children have become more cautious, and I have become hypervigilant. Every change in behavior raises a red flag in my mind. The fear I now carry is not a life that I ever imagined for my children. Yet it is our new reality. This summer, I struggled to send our son to daycare after we moved. The anxiety becomes so overwhelming for me that I almost pulled him out after just 3 days of being there, fearing the worst from what had happened to Olivia. Thankfully, Olivia is now in a school environment with teachers whom I trust, but the fear remains. I still scrutinize every detail of her day. I overanalyze every situation, and I am constantly on alert for any signs of distress, whether it's just a bruise or a change in behavior. The trust we once had in the world around us is shattered. Sending my children to school or leaving them in the care of others now feels like a risk that I cannot fully bear. The ripple effects of this trauma has permeated every part of our lives. I am deeply concerned about the long-term emotional scars that she may carry. I wonder how this experience will shape her sense of safety, her relationships, and her future. No parent should have to question whether their child will carry lasting pain from something that they never should have had to endure. I also understand that the fear and the anxiety that I live with will not disappear overnight. This trauma has fundamentally altered me, both as a mother and as an individual, and I am no longer the person I was before the abuse. I am forever changed. Your Honor, I ask the court to remember that behind this case is a real child, a baby who was frightened, abused, and betrayed. I ask the court to fully understand the deep, lasting harm that this has caused to Olivia and our family. She deserved to feel safe. She deserved to be protected. Instead, she was harmed in a way that no child should ever be harmed. The consequences of this abuse will affect us for far longer than this legal process. I thank you for allowing me the opportunity to share the impact this trauma has had on our lives, and I hope the court's decision reflects the gravity of the suffering and the fear that my family continues to endure. Thank you.
Macy Hyde's pain is unimaginable, but here's where this case gets complicated. Because Sarah Fuson's mother is about to take the stand, and her pain, it's real too. This isn't about choosing sides, it's about understanding that tragedy doesn't just destroy one family, it shatters two.
Sarah.
When Sarah was born, she was the biggest gift in our life. We just enjoyed, she was the sweetest child. She gained the nickname Sweet Sarah. Everything about raising her was a joy to me. She was actively involved in so many activities and so many things. We were actively involved in our church. And one of the greatest blessings was she was baptized at age 7. And that gives me lots of comfort.
If you would describe for the judge the impact that this prosecution and trial has had on Sarah.
The impact it has had on Sarah is great. From the beginning, there was an immense amount of media and social media coverage because of who her father is. This caused extreme embarrassment and shame. I knew that that day, January the 10th, when I came home from work and heard what Sarah's account, that very confident, independent girl that we knew and raised was gone. As time went on, she felt that life had no meaning and like she had a gorilla on her back. She attempted suicide. We committed her to a mental hospital for a couple of weeks. She came home on lots of mind-altering medications. The medications would change off and on. In the process, she's gained about 50 pounds. When we got her kind of back a little bit mentally stable, trying to get a new job was very embarrassing, to say the least. She would attempt one after another. With the charges on her record, it would come back when they did a background check. So she would get fired. And some of those firings were very, very humiliating. During this period, I made sure Sarah was with me or someone at all times. I did not feel safe leaving her by herself. Everything is worrisome and extremely painful. Finally, she landed a job. She made friends and she started thriving, but we knew this trial was looming over us, and we were not going to get through this unscathed. Her anxiety was eating her up. The girl that you saw in court during the trial was ridden with anxiety and was not the same girl that I raised. It's the amount of pain all of this has caused has been a very heavy burden to live with and to carry, and we will continue to live with and carry this.
Is there anything that you would like to say to the Hyde family?
Yes, I would. I've wanted to speak with them from the very, very beginning. I am so sorry for all of your pain and all of the trauma and all of the mistrust in society that this has caused you. I've tried. I wanted to from the very beginning to reach out. I was advised not to. I even wrote you all a letter. And I know it wasn't given to you. We do not, as a family, condone what Sarah did that day. We don't, but we do love our daughter. And just as you, anything your children do in life, you try your best to raise them and support them and get them through the hard things in life. I do know that Sarah did not go to work on January the 9th, 2023, thinking she was going to harm a child. Also know that Sarah did not think her actions at the time were hurtful. It was only when she saw herself on video that she thought, yeah, that was rough. Sarah was raised in a home of public servants. She only wanted to serve others. She reverted that day back to the daycare training at nap time. She should have never, ever, and no one should ever work in a daycare where you are enclosed in a room with lots of children by yourself. Daycare system needs a big overhaul. Lots of training, lots of supervision. And there should always be more than one adult in a class, regardless of the number of children in that room. Regardless of everything that you guys have been through and what we have been through, Sarah is not a throwaway person. She is kind, she is generous, she is loving. As her family, we need her, we depend on her, and we will have a big hole at our table and in our hearts until she is returned home to us.
Thank you. Those are my questions.
Jennifer Fuson's testimony hit hard. She apologized. She begged for forgiveness. But she also said something that's going to haunt this case. Sarah didn't think her actions were hurtful until she saw herself on video. Think about that. What does it say about the daycare system, about training, about supervision, or does it say something else entirely?
Go forward with your statement.
I want to start by apologizing to Ms. James, the probation officer, about my comments about the case. I was still adjusting to jail and was going through a difficult time. That's not how I feel about the case. I never intended to hurt Olivia. I had been working at Tylertown for 6 months when this happened. I loved my job, I loved the children, and I got along very well with the staff. I used to look forward to going to work every day, to be with those children and be in the environment. I was always alone with 6 children in my classroom. Sometimes it was difficult to give one child the attention they needed when I had 5 others to care for. I find myself hurrying and multitasking all the time. It was also hard to give the new children the attention they needed to transition into the toddler room. I didn't realize I was being rough with Olivia in the moment. I recognized that I was rough with her and regret my conduct. To Olivia and her parents, I am so very sorry that this happened and what this has put your family through and the trauma that Olivia had to go through. If I could go back and make this right, I would have been calm and gentle as usually I was and not rough. I love children and animals, and it is not in my nature to be rough. I hope someday that Olivia and her family can forgive me and we can move past this. I want to thank my parents and my family for supporting me and standing by me through this very difficult process.
Sarah's apology was brief, measured, and the judge, he's not buying it. But before we get to his decision, the defense attorney is about to make one of the most passionate arguments I've ever heard. He's not just defending Sarah, he's attacking the entire sentencing system. And whether you agree with him or not, you need to hear this.
Good morning, Your Honor. Good morning. Be a little longer. Sentencing spread for Class A felony. I know there's another count. but we're here to talk about the Class A felony. That's the sentencing spread is 15 to 25 years. Under recent amendments to the law that apply in this case, it is a 100%. There's no parole. There are no credits. Served every day. My position is pretty simple. The government's pleadings say they want a sentence more than 15 years. They haven't said what number they want, but they want it more. I think that a sentence of more than 15 years is brutal, unnecessary, and consistent with the sentencing law. I want to think about 15 years for a minute. I think everybody on this side of the table went to college, most of us. That's 4 years. 15-year sentence is 4 times of being in college. When you put it in real terms of spending time, it's forever. The college was an education, and for most of it, it was having a good time. Being in prison for 15 years is being locked up in a cage. I was at the penitentiary at the women's prison 4 days ago, parole hearing. There's barbed wire everywhere, silent as a tomb. You don't throw sentences around like candy anymore. There's no such thing as a mid-range sentence to make everybody happy at one end or happy at the other end. We are talking about real years here. State sentencing memorandum focuses on the aggravating factors, which I'll address in a moment. But there are other important parts to the sentencing statute. It's no secret that I served on the Sentencing Commission and was vice chair of the Sentencing Commission for years. Sentencing Commission was necessary because our statutes were in horrible disarray. Sentences were completely out of whack, and we wanted to bring some order to things. So let's talk about the vulnerability of the victim. It is an element of the crime. The element of the crime was enacted as Haley's Law back in 2025 when they enhanced it by children under 8 who suffer severe abuse. That's the point of it. To say that this child was severely injured or whatever is an element of the crime. There's no other way to talk about it because they had to prove severe injury. They had to prove that the child was under 8. This is the same exact thing. And if it does apply, it is so close to an element of defense, it runs the risk of double counting. So I suggest that factor's off the table. Now, the next factor is that this happened in a place where there's children. It duplicates the position of trust factor. She had to be there if she's in a position of trust to be a daycare operator. She had to be there for this thing to have even occurred. That particular enhancement factor is designed specifically, we read it common sense, of people that go to schools and have school shootings and harm the school as an entity. That's the whole point of it. It's an absolutely appropriate enhancement factor. Totally, because if some person shows up at a school and starts shooting the place up or committing violence in a school where there's kids and stuff, of course that needs to apply. That's not what happened here. The aggravating factor needs to be read with a dose of common sense. That's the whole point of it. That's why it's there, and it duplicates the position of trust factor. So I suggest that's off the table. It's just not applicable here. And if it is, it's de minimis because it's not what it's designed for. And then we talk about the position of trust. She was not licensed. She was in a position of care of these children. And yes, so I suggest that that enhancement factor may apply to some degree because she had care of the children. I was not unmoved by the mother's testimony at what happened to her child, that she put her child in the care of the daycare and my client. So is there a position of trust there? To some degree, there is. I don't want to be disingenuous and say that it's an irrelevancy. Of course it is. But I suggest that it duplicates the other factors to where they don't apply, so we're just dealing with the one situation. But think about, this offense could not have occurred unless she was in that particular position. So it's duplicative. Now, let's talk about the mitigation, which we have to consider, because you consider the aggravating factors and the mitigating factors. The mitigating factors are abundant. My client, I don't think had ever been arrested in her life. No prior record at all. This event occurred on one occasion, and not like the many child abuse cases that Your Honor sees where it goes on for weeks and months and years. It's an isolated event. So those are mitigating factors there. The fact that she tried to commit suicide, the fact that she was despondent over what she had done is huge mitigation in the case and detracts from whatever abuse there exists. And so I suggest that when you consider all this mitigation involved in the case, that 15 years is the appropriate sentence. Now, there are other factors that the court would want to consider. When the statutes were enacted, they were 30%, 35% for range one offenders, which she is. The sentencing grid was designed for parole. That's the way it was. So when you have a sentence of Class A of 15 to 25 years and there's a 30% parole, the courts would consider parole as part of it. Even if you gave the minimum of 15, then the person would be eligible after 5. But now the sentences are at 100%. The sentencing mindset that we had 5 years ago is inapplicable today. Our sentences have gotten inflated, but there's no change in the sentencing lengths. It doesn't work the other way, unfortunately, when the sentences are at 100%. So we don't have to talk about the fantasy that we engaged in where you say, well, you give somebody 9 years and maybe they'll be out in 3 and maybe they won't. So maybe we can adjust the sentence accordingly. This is real time. It's just like the federal government. When Mr. Strines and I go to federal court, it's 100% over there too. But the federal government had some common sense, if you can believe that. They reduced the sentence lengths to account for doing away with parole. And we engaged in utter madness in our state, where we left the grids the way they were and went up there. This is not the time or place for me to complain about that. We'll pay the price for that one day. And there'll have to be another sentencing commission to undo all this mischief. But the problem is, Your Honor is imposing a sentence today that's 100%. That will not change. We incarcerate more women in this country than any other country in the world, with the exception of some Middle Eastern countries that actually kill women. The purposes of the sentencing and the guidelines must be considered. Your Honor knows that. The court's going to articulate that. Let's talk about that. The sentence says under 102, must be imposed that is justly deserved in relationship to the seriousness of the offense. Justly deserved. Why in the world does this girl need more than 15 years at 100%? The law also requires elimination of unjustified. Punishment must consider restraining defendants with a lengthy history of criminal conduct. That we not have that here. Ms. Fuson does not have any prior history. Next, the court has to consider whether other measures less restrictive than confinement have been applied unsuccessfully. She'd been on probation 5 times, violated them. Of course, the court would consider that. So we've tried everything we can. Your Honor does that every day. That's not what we have here. And most importantly, the sentencing principle says the sentence imposed should be no greater than that deserved for the offense committed. That's the so-called parsimony provision, the least possible sanction. No greater than that deserved. We have to balance everything. Why in the world should this woman deserve more than 15 years in hard labor in prison? In 15 years, Your Honor, nobody's going to care or know.
Are we now having inmates perform hard labor like chain gangs in the prison system
No, they
that I'm
don't,
unaware
but that's
of?
what the statute seemed, the statute said you got to give them a Bible, that they're, they have these archaic.
I just didn't know when you mentioned 15 years at hard labor that was actually an accurate representation of our prison
No,
system.
not any, well,
I understand it's an eloquent reference to other images that we create by putting people in prison, but go ahead, I'm sorry.
Your Honor, I don't want to go too far afield, but I have had constant calls of prisoners being subject to abuse and killed in prison.
I understand that prison is not a pleasant experience.
It's without using profanity in the court, it's heck on earth. It's a terrible place. It may not be hard labor per se, but it's a hard life. People are extorted like crazy over there. Anyway, but I mean, the original statute says you got to give them a Bible and you're supposed to do all that, but it's not a good place. It's a terrible place. So I suggest the least severe measure is 15 years. Now, I want to talk about the offense a little bit. I wasn't here for the trial. The offense is aggravated child abuse. It's the one offense that's required to commit knowingly. Now, knowingly, we know what knowingly means for murder. We know what knowingly means for most offenses. I mean, you have to intend the result. Child abuse can be committed effectively in a reckless mens rea because it's objective and subjective. You're aware that you're hurting the child, or you should be. That's the definition of knowingly. We have a separate definition of knowingly for child abuse. So if she said, I did not knowingly intend to harm this child, that's true, but she did nevertheless. But she was acting in a reckless way because the statute said should have known. And should she have known that she was harming this child? I suppose so. But I suggest this is much different than the child abuse cases that Your Honor sees, where the child is being shaken all right to the point of death. And they know what's happening, and they intend to harm the child that she didn't intend to harm. I suggest that should be weighed in the balance as well. It doesn't diminish the pain that the parents feel, but it's not the intentional crime. Now, let's talk about 4035-210. It says that the minimum sentence within the range of punishment is the sentence that should be imposed because the General Assembly set the minimum sentence for each felony class to reflect the relative seriousness of each criminal offense of classification. That's what it says. The minimum sentence should be. Is child abuse, aggravated child abuse, serious? Absolutely. But the statute puts it 15 years for that because it's serious. But that's what the statute says. And then you weigh the aggravating and mitigating factors. But I suggest that this is not that complicated. That's what the statute says. It's the minimum sentence. That's what the legislature said. Then you have to consider how long a defendant's going to serve before becoming eligible for release. 4035 says the court must place on the record the estimated number of years and months the defendant will serve before becoming eligible for parole. It's truth in sentencing. So when you impose a sentence, you say, well, everybody, we think she'll be eligible for parole after 30% or 40%. You have to consider that and tell everyone it's 100%. The court should consider that as well. And then you have to consider the evidence on the pre-sentence report and the strong R. What is a strong R? It is a risk assessment. Its risk assessment is low. That is a factor the court's required to consider by, is she a threat? No, she'll never work in a daycare center ever again in her life. She'll never be near children in the rest of her life. Impossible. Her risk is low. Is that a mitigating factor? Of course. If it was high, the state would be up here saying and waving it around. They're not. This is not an issue of how tough we can be or what it looks like or making one side happy. Let's look at the person as an individual and ask what is deserved. Locking this woman up in a cage for more than 15 years, I suggest, the state suggests, their position is unconscionable, inconsistent with notions of mercy. And please do not think that the government will come back up here and say, well, what's another daycare worker going to say? Well, I can abuse this child all I want because I'll just get the minimum sentence of 15 years at 100%. That's not, they're not going to say that. The deterrent effect of imposing sentences diminishes to insignificance after 5 years. Any sentence of more than 5 years, except for maybe for murder, the deterrent effect doesn't have any more effect than that. The numbers become unreasonable, have no added deterrent effect. So why say 16, 17, 20 years that we're going to deter this sort of behavior? 15 years will deter any human. For all those reasons, I'd ask, this person here is a human being. These laws were designed to reflect a sentence for her. The indictment is the state of Tennessee versus her. And the court is the arbiter of what that sentence should be. That's why we have judges. Sentencing guidelines are advisory, but at the end of the day, it's a very human experience. 15 years at 100%. I never thought I would stand in a courtroom in this state and say that such a thing. That's where we are today. No sentence more than 15 years is deserved and would be inconsistent with the rest of the guidelines. And I thank you, Your Honor.
15 years at 100%. No parole, no credits, that's what the defense is asking for. And honestly, part of me understands the argument, but the prosecution is about to remind us why we're here, and it's brutal.
Holder, Mr. Moore.
With all due respect to counsel, and I've been around for a long time, and I've heard this before, and perhaps it should be addressed to the legislature, but that's not where we are here today. Your Honor, presided over this trial, you've heard all of the evidence, read the pre-sentence report, considered the statements and testimony here today, and on behalf of the state of Tennessee, I would submit that, yes, at this point in our history, the legislature, for some crimes, has decided that, yes, a person must do real time for a real crime. And this was a real crime whose effects will last far beyond 15 to 25 years. The state submits that the enhancement factors that we argued, that General Holder argued, are present. Case law, yes, it's under 8, it's not double counting, because a 6-year-old or a 7-year-old could come in and testify about what happened to them. That's the entire reasoning for the State v. Adams and the cases that follow, and that's been for 20, 30 years, at least. Happened on a pre-K, there's no dispute about that. Not that, oh, this enhancement factor applies if it is on the grounds of a pre-K and committed by someone who has a firearm or someone who is shooting or killing. No, no. Legislature could have done that, and they may well do that. They've added enhancement considerations before, but that's not what this one says. And obviously this was conceded where Ms. Fuson, that child was placed into her care, custody, and trust. She betrayed that trust, as we have seen time and time again. The arguments for sympathy and mercy in this case, I submit, are not and should not be well taken because of the facts of this real crime. State certainly submits that whatever sentence Your Honor imposes will be based upon the law and the evidence, consideration of all the factors. But on behalf of the state of Tennessee, Olivia Hyde, family of the state, does sincerely believe this should be more than.
This was a real crime. Those 5 words just ended the debate. Now it's up to the judge. And what he's about to say is going to shock you, not because of the sentence itself, but because of how he dismantles Sarah's credibility piece by piece.
The minimum sentence. Thank you.
Well, any court that has to impose a sentence in a case like this is required to follow, as has been pointed out by both sides, the considerations and the guidelines that our state legislature has put in place to govern the sentencing in criminal cases. Those sentencing considerations are set forth in Tennessee Code Annotated 4035-103. And that provision states the following: to implement the purposes of this chapter, the following principles apply. Sentences involving confinement should be based on the following considerations. Confinement is necessary to protect society by restraining a defendant who has a long history of criminal conduct. Confinement is necessary to avoid depreciating the seriousness of the offense, or confinement is particularly suited to provide an effective deterrent to others likely to commit similar offenses. Or measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant. Obviously, this, as has been pointed out, is a case that requires whatever sentence I impose, the minimum sentence is 15 years, and the service is 100%, meaning she's not eligible for parole at any point in time. So some of those considerations are not really relevant. Obviously, the only one this court would be inclined to consider of those factors would be that, it is in this court's opinion important not to depreciate the seriousness of the offense of aggravated assault against a minor child of 13 months. But the rest of those factors don't really apply in this case. The sentence imposed should be no greater than that deserved for the offense committed. Mr. Rabin makes an eloquent argument about the fact that our state legislature and the sentencing guidelines are that the minimum sentence is the sentence that should be imposed unless there's some basis for not doing so. But that's why we consider the aggravating and mitigating factors to help determine whether the minimum sentence is the applicable sentence. Inequalities in sentences that are unrelated to a purpose of the chapter should be avoided. The sentence the sentence imposed should be the least severe measure necessary to achieve the purposes for which the sentence is imposed. It goes on to talk about the potential or lack of potential for rehabilitation or treatment of the defendant should be considered in determining the sentence alternative or length of the term to be imposed. So those are just some of the factors that I'm required to consider. The first thing I'm required to do then after that is to consider the range of the defendant as a criminal offender. And there's no dispute about the fact that she is a range 1 offender, which means that the range of sentence for count 1, which she was convicted of aggravated child abuse, is 15 to 25 years. And that range of sentence for count 2, which is child abuse, and that is a range of 2 to 4 years because it's a Class D felony. Then the court has to look at the mitigating and enhancing factors in order to determine whether or not the minimum sentence should apply or whether or not a greater sentence should be imposed. Before we do that, it's important to remember, and I know Mr. Rabin was not here for the trial, but this court has observed this trial from the very beginning and listened to the testimony, listened to all of the medical proof that was provided. I have reviewed that video, watched the video that was provided at court, and I think the jury did too. And I think the jury not only watched it, but they watched it very intently because they, during deliberations, came back and asked to see another portion of that video that more or less highlighted the area that of concern regarding the injury to the child's head. And as a result of that, the jury found that the defendant had committed the offense of aggravated child abuse. The factors are, of course, not the factors, but the evidence also substantiates that she had abused the child by the bruises on the child's arms, which is what the triggering effect or the first notice to the mother in this case was that there were bruises on her child's arms, and Ms. Hyde then inquired us and brought that to the attention of the daycare, and the daycare pulled the videos to start looking, and they themselves alerted law enforcement. In other words, so it's important to note that not only did the mother have concerns, but the daycare operator, the management of the daycare, thought there was great enough concern after watching the video that they alerted law enforcement. So we can minimize some of the factors that we want to, but there's no question that there was evidence that this trial, that this child was harmed. I know the defendant has argued from the beginning that she didn't really hurt this child in a severe way, and has argued that through medical testimony of her own expert witnesses that the child was not actually suffering an injury to her skull, and that there was no skull fracture that occurred. But Dr. Lakin was the testimony of the state's witness, and she testified that there was both a concussion and a probable fracture of the skull, and that it did amount to severe child abuse. And the jury considered all of that testimony of all of the expert witnesses, and they found that, in fact, the defendant had committed the aggravated child abuse. Now, looking then to the aggravated and mitigating factors that I'm required to consider, state argues in their sentencing memorandum that the first consideration is the victim of the offense was particularly vulnerable because of age or mental disability. And as the defense points out, it is the statute we're dealing with that she was convicted of does make it a much more severe crime when it is a child below the age of 8 years. And as a result of that, the age of the child is a factor that's part of an element, if you want to call it that, of the crime for which she was convicted. I understand the state's argument that there is a basis for considering that no matter when the child is particularly unable to resist the crime, summon help or testify at a later date. But I have to agree with Mr. Raven that I think this statute, the way it's worded currently, would exclude considering that one in a case where the child is 13 months old, and as a result of that, I do not find that victim of the offense particularly vulnerable because of age or mental disability is a factor I can consider. Clearly it is the fact, but it's not a factor that I consider as an enhancement factor when the statute has been amended to make the crime of abusing a child under the age of 8 years to be a minimum Class A felony with a minimum sentence of 15 years at 100%. So I am, out of an abundance of caution, ruling that number 4 does not apply. Number 14, that the state says the defendant abused a position of public trust or private trust or used a professional license in a manner that significantly facilitated the commission or fulfillment of the offense. That statute does not require that the defendant have a particular license, nor that she be some professional individual that, in my opinion, at least, we have found people who were guilty, and that was an enhancement provision when they were just some family member that provided care, but they violated a position of trust. In this course of finding, there is no greater position of trust that we can put a person in than to provide care for a minor child. You know, we have a society that people have to work. It's a 2 household a family that has a two-income household almost to make ends meet. So they have minor children, they've got to have a way to provide care for those children. And when that is the case, they place those children in the care of some agency or some individual. And when you drop your child off to a child care person, there is no greater trust that you place in an individual in any way than the trust that you place in that person, that they will not only provide care for the child, but that they will not harm the child. It's one thing to negligently allow a child to be injured. It's quite another when the provider of care is the person who actually causes the injury to the child. So I do find that this is a position of trust, and that factor would factor in as an enhancement provision. I think the defense's argument that she was only in a position of authority is not relevant, nor do I think.
20 years, no parole. Sarah Fuson will be in her mid-40s when she gets out. Olivia will be in her 20s, and both of their mothers will carry this weight forever. There's no winner here, just a broken system, a broken family, and a baby who should never have been hurt in the first place. What do you think? Was justice served, or did the system fail everyone involved? Let me know in the comments.